Hi, Gary Klaben here. You know, on January 3rd of 2013, President Obama signed into law the American Taxpayer Relief Act of 2012. So why is that important? Well, in that legislation was some major estate planning changes that took place that is relevant to most folks who are successful investors. You know, many times we'll have somebody come in and we'll ask them if they have estate planning documents, and they'll say yes. And I said, well, have you funded your trusts? And they'll look at us funny and say, well, what does that mean? Well, it means taking your assets and changing them out of typically in joint tenancy to the name of your trust. And they kind of look and say, I'm not sure if we've done that. And invariably we find out that a lot of that hasn't taken place. So why is that important? Well, there's 5 common mistakes that take place here in estate planning. So here are the 5 common mistakes we see. 1, assets not properly funded. 2, outdated documents. 3, wrong beneficiary designations. 4, not funding a trust. 5, no plan for a surviving spouse. Now I want to pick that last one and give you an example. So we had a widow come to us, this is several years ago, and her husband had gone through a long cancer process, went to hospice, and eventually passed away. Well, one of the things they had talked about was selling the house if one of them passed away, and so first thing she wanted to do was look at selling their home. Well, they bought the home for $200,000 35 plus years earlier, and now we're selling it for $1 million. Done very well. Now the house had been titled in joint tenancy between the two of them. This is very common. Well, when he passed away, what the law says is that a jointly held asset gets half stepped up. What does that mean? Well, if the house is $1 million, and they bought it for $200,000, there's an $800,000 difference. Of that $800,000, half of that gets erased. That's $400,000. Or if we add that to the $200,000 original basis plus $400,000, we get to $600,000. That's the new basis. When she sold the home, there was a $1 million net income she received from it, minus $600,000 is $400,000 a gain. There's also an exclusion on your own personal residence. It's $250,000 for an individual and $500,000 for a couple. Well, she's an individual, so if you subtract that $250,000 from the $400,000, now you have $150,000 of gain. Well, she had to pay over $25,000 of taxes on it. If she had known this would happen, they could have changed the ownership of the house to her husband's trust, and then all that gain would have been erased and been no problem. That's just one example of something that can take place without looking and planning down the line for your estate. If you're married or you're single, looking at where it's going next. Why is it important? It's important because it's not just that arena. There's also probate to consider. In the state of Illinois, if you have over $100,000 of assets in your name, then those assets go through a formal probate process. It's not confidential, and most of us want our stuff to remain confidential. It's in the public record. Anybody can see those assets and what's going on with those assets. Again, folks want to avoid that. There's also funding, as we talked about, of these assets in a variety of ways to get them to our loved ones. The important point here is that periodically you need to take a look at your estate plan to make sure it supports what you actually want to take place, and you don't have these events that occur after the first death for widows or widowers where you're left with different issues that you didn't realize were going to take place. So the takeaway here today is to go to your most trusted advisor and look at your estate plan and make sure it fits what you want to take place in the future, and get it updated if necessary to meet the latest tax law that just was passed here a year or so ago. So until next time, enjoy.